Hello and welcome to this webinar. We're just going to wait a minute or two for people to join. Thank you so much for your interest in this important topic. Lots of people signed up. We were excited, if a little intimidated by the people who have all signed up. Hopefully this session can be useful and it will very much be a whistle-stop tour through Zambranos and the EUSS, given the complexity of the topic and the limited amount of time we have to go through it. I think most people are now here. So I am chairing today. I'm Ollie Percy. I am a barrister at Garden Court Chambers. Very excited to introduce our panel of speakers. I will be going first, giving a very basic overview of the EUSS and Zambranos. I'll be followed by Nisa from Coram Children's Legal Centre, who is a real expert on the ground making these applications. Next up is Bayana, another barrister at Garden Court Chambers and an expert in EU and immigration law. Closing the session will be Desmond, another barrister from Garden Court Chambers with particular expertise in welfare benefits. There will also be time for a Q&A. As chair, I am responsible for reading out the housekeeping instructions which I'll read out now. So the meeting instructions are as follows. You have been placed on mute. Please post your questions in the Q&A window. The chat function is enabled for any other comments, queries and/or feedback. Please do not post questions in the chat function. Resources will be circulated to all registered delegates after the webinar. This webinar is being recorded. What that means is the audio and video of the panelists and anyone who speaks, if they are unmuted, will be recorded. This webinar may be shared on our marketing channels, including our website and social media. Please refer to the instructions in the chat window, which Amy from Garden Court's marketing team has very helpfully posted, if you are experiencing technical difficulties. Without further ado, and in the interest of getting cracking, I will get started on the nuts and bolts of Zambrano carers and the EU settlement scheme. Brilliant. So that's me. And these are the key documents that you need to have to hand when you are navigating an EUSS and Zambrano issue. Apologies, my session is likely to be extremely basic and very familiar to many of the people here. But the purpose of it is that we're all on the same page and can access the other speakers' materials. So, Appendix EU, person with a Zambrano right to reside. What does it mean? Well, it's pretty much the usual definition, but note this health warning at B, without leave to enter or remain in the UK unless this was granted under this appendix. It's an exclusion of Zambrano carers with leave under other parts of the immigration rules, and it's proving to be a significant barrier in practice, as the other speakers will speak to. So, where do you find the information about Zambranos in Appendix EU? Well, I don't propose to go through the provisions in detail. You'll get my slides. This is more a shortcut for you to find them without having to trawl all the way through Appendix EU. So see EU 11. I've highlighted the relevant provisions. So this is for indefinite leave to enter or remain. In particular, 11.3, which makes specific reference to Zambranos. Note that part of the continuous qualifying period can be Zambrano and then another form of leave. You can stitch them together. For the requirements for limited leave to remain are found at Appendix EU 14. And the relevant parts are on my slide, and you can refer to them when they get sent to you. Don't propose to go through these word by word. So, the guidance. I'm going to go through the EUSS caseworker guidance, which was updated towards the end of last month, but not in material ways. So it is now version 4 instead of version 3. It but for our purposes, it hasn't changed much. So what's the first stage is assessing British citizenship. The next stage is assessing direct relative or legal guardian. The third stage is what is a primary carer. And then the fourth stage is the British citizen unable to reside in the UK or the EEA. So assessing British citizenship, these are the criteria. It can only be conclusively determined by the courts, but this is what the EUSS caseworkers will look to. It's pretty standard, no massive surprises here, but just flagging that you do need to read this, and it's easiest if your application is supported by one of these. No doubt Nisa can go into more detail about barriers improving this if necessary in the Q&A session. So this brings me on to a recurring theme, and probably one that others will speak to, is that a derivative residence card is extremely useful for the purposes of a Zambrano application. Indeed, probably, I don't know anyone that's actually succeeded in the Zambrano EUSS application to date who has not had a derivative residence card, but others might have seen that. And it would be really interesting if you have got those cases, if you could tell us in the chat. So it can be a shortcut through the stages. Again, primary carer, defined in EEA regs, and it's a pretty standard definition of primary carer that we've all seen before if we've done these cases under the EEA regs. Again, significant weight in the evidential process of proving that you meet the Zambrano carer requirements is placed on a derivative residence card. And then the fourth stage is the British citizen unable to reside in the UK or the EEA? Well, again, there aren't a huge amount of surprises in this test, to be honest. It's what we'd expect for Zambranos. The annoying part of this, and another sort of barrier to Zambranos, is whether there would be a realistic possibility of making an application under another part of the immigration rules, particularly Appendix FN. Now, so that creates two barriers, at least, that we have seen, arguably three. First, they have another grant of leave, and that's explicitly in the rules. Now, there's this guidance which says, look, if you could apply under Appendix FM, or otherwise rely on Article 8, then you should also be refused. So this together, these present quite a significant barrier unless you have a derivative residence card that you have a Zambrano, leave. So how do you get a Zambrano residence card? Well, the post-Patel guidance, which undoubtedly many will be familiar with, causes significant difficulties. Now, the post-Patel guidance purports to implement the Court of Appeal's decision in the case of Patel against Secretary of State of the Home Department. And this is what the guidance says in relation to Appendix FM. It says that you don't get your Zambrano card if you have a viable route under another part of the immigration rules. So that is the fetter on getting a a derivative residence card. And as such, it's now quite difficult to get this derivative residence card that is given so much weight in the application process. So not Zambranos is explicitly addressed in the guidance. And it's, again, what I have said. It's just a clear summary of the barriers to getting Zambrano status under the EUSS. And this slide essentially summarizes what I've just been saying and drilling into you. Derivative residence card is really useful and a shortcut throughout the application process. As such, query whether Zambrano carers are actually getting leave if they don't have a derivative residence card. And these issues will be spoken more to by Biana in her presentation, but if you look towards the bottom of the guidance, it reminds caseworkers to consider the following two issues. Can the British citizen live in an EEA member state? And are there alternative care arrangements? All in all, the mechanics for applying to EUSS for Zambranos and the criteria that EUSS caseworkers from the Home Office will be looking at present several very difficult to navigate barriers, which explains why the refusal rate for Zambrano carers under the EUSS is higher than any other category of applicant. However, there might be stuff that we can do about that, and hopefully the other speakers can give us some ideas about that, particularly Biana and Nisa. So I hopefully have kept to my 10 minutes, and apologies for the whistle-stop nature of that tour through the nuts and bolts of the rules and the guidance. But hopefully we're all on the same page now about the basics, and I will hand over to Nisa, the expert on the practicalities of applying to the EUSS for Zambrano carers. Thank you very much.
Hi, everyone. So I'm also going to try to do a bit of a whistle stop in terms of the evidence and practicalities of applying as a Zambrano carer. So the first step is to establish the nationality and identity of the applicant of the Zambrano carer. And that can be done by way of providing an ID card or a passport, just showing their identity and nationality. If, however, that can't be obtained, the general EUSS guidance does provide, does allow for someone to explain where there are exceptional circumstances or compelling reasons why that can't be provided. The next part is to show that the person does have a Zambrano right to reside. So that can be broken down into, first of all, showing the residence period that the person is relying on and showing that there hasn't been a supervening event. And that can be done through providing bank statements, council tax bills. If they've got employment, they can provide wage slips, or if they've been supported by social services, they can provide a letter. What to remember here is that the period of residence starts from the moment that the child is British. So they may be born British, but they might have registered as British. And what they need to show is 6 months in every 12-month period. So it doesn't have to be completely continuous, but as long as every 6 months in 1 year is covered, that should be fine. The other thing to show is that the person is not exempt, which means that they don't have a right of abode or right of residence under any other EU provisions, and that they don't have indefinite leave to remain. So that should be fairly easy because that's just a question of fact. Then showing that the child is a British citizen. And so here it's important to provide a birth certificate. If there's a British passport, a copy of the British passport, or a certificate of registration as a British citizen. And then showing that the applicant is a direct relative. So that is obviously in the case of a parent, that's pretty straightforward and can be evidenced with the birth certificate. But where there is a guardianship order, for example, then the court order needs to be provided. Then it's going through the process of explaining how they are the primary carer. And that basically means showing the responsibility that they've got for the child. And so a GP letter here is quite important. That can show that the parent, is taking care of the child. Letter from schools, potentially letter from social services where there is any kind of care arrangement, or where there is, for example, Section 17 support that's being provided. And then it's showing that the British child is unable to reside in the UK or EAA. And that's got two elements to it. One is to show that there is no alternative care arrangement in place, and the second part is to show that they don't have leave to, that there isn't a realistic prospect of success under an Appendix FM application, basically what Ollie was explaining. And so the alternative care arrangement, what that means is that they need to show that what is the status of the other parent. So that's quite important. What you're essentially showing is taking into consideration the child's best interest. Is it appropriate for another person to care for the child? So the whereabouts and the immigration status of the other parent. They will accept that there is no alternative care arrangement if that other parent is not a British citizen or doesn't have a right to reside in the UK, or they're outside the UK. And so that should be, in a lot of cases that I have done, that hasn't really been an issue, but it can be an issue where, for example, the parent is a British citizen and you need to show why they wouldn't be able to care for the child. And then they would also look at whether there could be another direct relative or legal guardian in the UK who could care for the child. And the Zambrano guidance actually sets out who is considered, an exhaustive list of who is considered as a direct relative, and that will be parent of the child, their brother or sister, or grandparents, or uncles. So, and it's not just in the UK, it would be also any direct relative residing in the EU. So an explanation would need to be provided as to why it is not appropriate, why it would be unsuitable for them to care for the child. And a mere assertion is not enough. And in these cases, I think it's really important to have a statement from the applicant and potentially a letter from the direct relative to explain why that is not appropriate. And issues such as finances, for example, they're not going to take that at face value. It really has to be explained on a practical level why it's not possible. And looking at the child's best interests, and the guidance sets this out as well, it's setting out what would be the effect on the child if they were to be separated from the applicant, the effect on their education, on their welfare, on their connections and support system that they have in place in the UK with school or any other activities that they're involved in. So that part is actually quite important. But there are also situations where they will accept that it's unsuitable, where there is, for example, child protection issue. And the other part that they will look at is this issue of Article 8 application. And that is a bit tricky. So just like Ollie was saying, where there is a derivative residence card that has already been issued under the regulations, it's much easier. Our experience is they will just grant them. Just as long as you are able to show that you continue to be the primary carer. If you don't have leave to remain under Appendix FM, or if you have leave to remain under Appendix FM and at some point had a derivative residence card, then they are likely to refuse the application. So just in terms of thinking about this, I think it will be a bit tricky, because the applications, for example, that we have said, I think representations would be very important here to set out why actually the guidance is not correct in its interpretation of Patel, that the two routes are quite distinct, and they shouldn't be conflating the two. So I think it's worth really setting that out properly. It doesn't mean they won't refuse it, but at least it would be important for an appeal, which Bojana will go into more detail later. In terms of considering, one of the issues that I think has been arising recently, or kind of has gained a bit of momentum, is that the fact that people who have got leave to remain under Appendix FM but had previously been issued with Zambrano cards or hadn't, whether it's worth actually making both applications, and the guidance does allow for that. So they may need to make, for example, an extension application on the Appendix FM route, the 10-year route that they're on, but they can also make a Zambrano application. And because it would be the extension application would be a human rights claim, then they should be considering both applications. But I think just a bit of a disclaimer there, that I think it's really important to advise clients that they should be putting in the extension application as well as putting in a Zambrano application, because the 3C leave would continue, I think, with the if Zambrano application is made. But if it's refused and a subsequent appeal is dismissed, then it stops there. So and obviously there can be implications also in terms of access to benefits and things like that. So I think that's an important one to bear in mind, as in both applications need to be made. I think I've covered everything, but please do let me know if you've got specific questions or if there's something that I haven't covered or forgotten.
Thank you so much for that, Nisa. That was really interesting and very practical and helpful. We'll hand over to Bojana now, and I'll let you take it from here, Bojana.
Thank you very much, Ollie and Nisa. I have Amy kindly sharing my screen, I understand. And this will be another whistle-stop tour, piggybacking on some of the matters that have been raised already. But I will only cover 3 issues that do arise in appeals and try to tie them in with the both substantive EU background insofar as it's relevant and the EEA regulations in particular. So I start with a reminder, and I hope you'll find these links useful, of what the key cases that dealt with the provisions of the Zambrano right to reside, based, of course, on the first case, which is Zambrano, which provided that basically a right to reside arises where not to be given it means that a person is deprived of genuine enjoyment of their right to citizenship. And we had a series of cases. I think the Grand Chamber has dealt with a number of cases in this area. The important one is Chavez-Wilches, which is also there with the links, which showed that the previous practice of the Secretary of State, not that it was a British case, but it had consequences in the UK, to see the availability of a primary carer for a child as conclusive evidence that they would not be deprived, that the child would not be deprived of genuine enjoyment of their right, i.e. there is another parent, off you go. Nothing to see here in terms of Article 20 of TFEU. There is CS, which told us that the expulsion criteria are the EU expulsion criteria, so much more difficult to expel, to deport. And if I can have the next slide, please. Here we have in the UK courts cases which, in my view, remain germane if you find that what the Secretary of State is doing by way of policy is distorting what the courts have done in the UK. And Patel in the Supreme Court, Patel in Court of Appeal, and MS Malaysia, which I would urge you to read, especially if you're dealing with alternative care, be it for children or be it, as MS Malaysia dealt with the adults, i.e. we've got a British citizen adult dependent on care by another. Next slide, please. So Secretary of State tells us that the Zambrano right is a CJEU one, and her policy refers repeatedly to what's been decided by CJEU judgments. My view would be that is not necessarily always followed when one looks at the substance of those matters. But Patel in the Supreme Court is the authoritative judgment that is binding on in the course of all appeals, and these appeals, the Secretary of State certainly doesn't consider the fall within the withdrawal agreement. Might be some arguments made about that, but they are extremely difficult arguments, and perhaps one should wait and see about those. There's certainly no direct reference to it. What we have is the rules, Appendix EU, and they establish the important criteria which are imported from Immigration European Economic Area Regulations 2016, as they were at the point of the 31st of December last year, and they're reproduced here. You are no doubt aware of them, and this is the essence of the test as defined by Secretary of State's regulations. The person is a primary carer, the British citizen is in the UK, and the British citizen would be unable to reside in the UK or in another EA state if the person left the United Kingdom for an indefinite period. That is the core of the imported written test. So it's not what has been said elsewhere. The core of the test is the one that the Secretary of State decided to write in the regulations. Next slide, please. We can see how that is summarized, and I will not take you through this. You can see that all those matters that were described by both Ollie and Lisa are there. Next slide, please. Amy, next. Oh, so, thanks. And we come to a point that arises still in appeals, well, in refusals, which is that a person, that a leave is refused on the basis of a person being an exempt person when they actually, that didn't matter for the purposes of the regulations. And what I want you to remind you of is always go back to the letter of the regulations, which feature in the qualifying criteria for the EUSS. So in order to meet the criteria, one must not be an exempt person. And this is 4 categories of people, of which we have another person who has a right in the regs, and 2 kind of broad categories, and a person who has ILR, but not under EUSS. Next slide, please. What you can see here is that what the Secretary of State, the way the Secretary of State describes this in some detail fully reflects this. And then next slide, please. The Secretary of State will have to consider whether, if it's someone who otherwise would have met the regs, and that's why they're exempt, they might qualify under EUSS. If that's the case, all very well and good. If it is another of the criteria, such as having a right of abode or being essentially a diplomat, this is a peculiar, mysterious term appears in the guidance, saying that their application would be void. This is not terminology under the rules anywhere. I do not know what it means. I assume that what it means is refusal, but it actually affects a very, in a meaningful way, a very, very narrow category of people who are exempt because they were family members of diplomats or they were diplomats themselves. Next slide, please. Now, Ollie has already taken you through the criteria for primary carers. And what's important here is that one can share the responsibility for care with another person. It used to be the case that the Regulation 16.8 used to say that this only applied if that person was not an exempt person. That was jettisoned. The regulations were amended. Nevertheless, even though it's been years, there are still refusals on this basis. So remember to read the regs. It's not there, shouldn't be done on that basis. Next slide, please. The interesting bits about guidance to do with shared responsibility is that this is a flexible approach. You do not have to have like 100% of sharing responsibilities, and this is illustrated in the guidance itself. Next slide, please. The important bit from the Secretary of State's perspective, and that is reflected from the regulations, is that if one is talking about equal share of responsibility, we are talking about that happening at the same time, or that we can identify those periods for the relevant period for the purposes of EUSS, where we have a sequence of either sole responsibility or equal sharing. Next slide, please. Now, you have heard already about being a primary carer and being unable to reside as one of the core issues that that arises in these appeals. Alternative care issues, which there is a whole section in the guidance about alternative care and whether that alternative care is appropriate. Much of it is useful, but much of it seems to be focused on complete inability. And I think when it comes to appeals, it is useful to have those authorities that the Secretary of State says their guidance is based on, such as KA, Chavez, Vilches, and NY Malaysia, which do tell you this is not the end, but some alternative care might be available somewhere. That doesn't mean that the right to reside has been defeated. Next slide, please. And finally, the point about previous leave. You have heard this is one of the defined points where one is a carer will be excluded because vast majority of the time this has been excluded because of Article 8 leave. Next slide, please. The Secretary of State has beefed up this section in the guidance, which talks about the Patel cases. And the important bit that they say is basically because there is a reference to a backdoor route in Patel in the Court of Appeal as being the Zambrano right, which defies the right, otherwise regular entry and leave to remain under Article 8, that this somehow means that two are mutually exclusive. What we find in this iteration of the guidance is that there is a mention of Patel in the Supreme Court, which reverts to compulsion as the key part of the test in Zambrano cases. Next slide, please. It is a bit muddled the way that the Secretary of State describes these, and this is why. First of all, Patel in the Court of Appeal, as well as the Supreme Court, concerned constructions of EU obligations, not what was written in the Secretary of State's regulations. The issue of whether or not alternative grant of leave mattered did not arise in the facts. Nobody had that alternative right of leave. There was a possibility of applying. And when the Patel was decided in the Supreme Court, it was not necessary to deal with the matter. Also, when you read Patel in the Court of Appeal, the way the structure of the judgment is, it's clear that you have Article 8 as being relevant to or material to the Zambrano right to reside, but it does not dispose of the issue whether you have it. So all this together shows that in terms of the way the Secretary of State has defined the rules and its guidance, there are real problems with it. Next slide, please. We're reminded of these criteria, and next slide, please. This is kind of the core for your representations, if you like, or you might find them useful. The construction of Regulation 16.5 turns on if, because you have a right to reside if, should the people who are your carers leave, you would be forced to leave. There is a test case on this matter, which it's a very important and broad challenge, which will be dealing not merely with issues of statutory construction, but really important associated issues of discrimination, the extent of applicability of EU law, all sorts of issues, which will be heard by expedition on the 20th of May. I think I will leave it there. I'm sorry if I've gone over, and I'll hand over to Desmond, noting there are two situations in which it matters whether Zambrano right arises and why, and that is when you have somebody who has been committing offences potentially after they had had previous leave on different bases, and that normally, according to current practice, requires the Secretary of State to make another decision to say that a previous deportation order made under non-EU provisions is enough, i.e. it amounts, the person who's being deported amounts, their conduct amounts to conduct that would meet the EU deportation criteria. That's normally done in your refusal. There will be a few paragraphs about this, and it's enough for the purposes of EUSS. The second issue is benefits. Obviously, we have Desmond who will tell you all about why it matters and when it matters, or it doesn't matter. Thank you.
Hi. I was going to be sitting in the background responding to any benefit questions if they came up, but it looks like I'm going to be rounding up what the benefit situation is. So I'll do that in 3 minutes. Basically, the benefit rules for Zambrano carers haven't changed, but there's been a test case that looks at the purported exclusion of pre-settled status rights, and that now is in the frame. So just to go back to the beginning, you recall back in 2012, the right to reside based upon Zambrano suddenly became a non-qualifying right for benefits. So it's just no use to you if you wanted to claim benefits purely on that right. There was a possibility that when the EEA regulations changed and were consolidated into the 2016 regulations, whether that made any difference, and the upper tribunal said no, that made no difference. So that was the end of that. The status quo remains. Just a caveat to all of that, it only applies to benefits that have a right to reside requirement, and so disability benefits can still be claimed by Zambrano carers, and that includes Zambrano care of an adult, so PIP, etc. The other little exemption is if your Zambrano carer client is a national of Algeria, Morocco, San Marino, Tunisia, or Turkey, they might be able to claim child benefit under an obscure EU regulation. But the news is that there has been a challenge to the exclusion, the attempt to exclude people from benefits based upon having pre-settled status. That suddenly became a non-qualifying right. But that was challenged in a test case. The CPAG were behind it, Bratilla, and the Court of Appeal agreed with them that because they were given a right to reside under domestic law, the attempt to carve out and target EU citizens alone was direct discrimination. Secretary of State appealed, and it is due to go to the Supreme Court on the 18th of May, but in the meantime, a tribunal in Northern Ireland referred exactly the same question to the Court of Justice in the European Union, and that's being considered today in Luxembourg. So, if that was successful, well, the Court of Appeal have already quashed the legislation that attempted to exclude the pre-settled status. So if that was upheld, then that would open the door for all those EA nationals who are struggling and waiting for their full settled status to come to life 5 years down the road. Of course, the disadvantage Zambrano carers have is they don't have a fallback position. Other EA nationals, if they exercise some sort of EU right and become a qualified person under the saved version of the EA regulations, they can get by. But Zambrano carers can't do that. But if it was successful, the test case, then that would appear to open the door for all of those in that class. And a similar exclusion was incorporated into the housing assistance legislation. So one assumes the same would happen. But will it happen? How will it happen? Will all depend upon what the courts rule and how the government reacts. That's my little summary. I'm sure no questions will arise from that.
Thank you so much for that, Desmond. And we do have some questions, which I'm not on that actually, but I think probably makes sense for this one to go to Nisa. It's from Ed O'Driscoll. When there is only circumstantial evidence that the child was born a British citizen, birth certificate, expired passport number for British citizen father, old parental responsibility agreement, but no absolute proof due to lack of cooperation from father, is there any onus on the Home Office to make their own inquiries as to the child's nationality when making an EUSS application?
It depends on the circumstances of the case. I mean, if for example, there isn't an onus on the Home Office, I think, as such, but I think with the evidence that is available, an application could potentially be made, and then putting the onus on the Home Office to say that they should be making their own inquiries because the the relevant information has been provided. As to whether or not they do that is obviously a separate issue and would depend on the reasons or lack of reasons that they might provide. But I think an application could be made. And if there has been, for example, any domestic violence issues, I think that's really important to set out there. That might be one of the reasons that the father is not cooperating, for example.
I completely agree with that. And one barrier that the Home Office might put up is data protection, that they can't look at another person's records or do their own inquiries because of data protection. If they do that, come back with that, seek advice, because quite often that's not a valid reason for not doing that. I can't advise in specific cases, but I have given advice in relation to the issue of data protection being used as a false barrier for the Home Office conducting inquiries. And it's perhaps used a little bit too loosely in my experience, but obviously it'll be a case-by-case basis. Great. If people could put their questions in the Q&A box rather than the chat box, that will make it easier to manage. Thank you. We have some other ideas as to how to deal with that from Mary Christine. It could apply to Home Office for confirmation that child is British, form to fill in and fee to pay. Nationality Department will look into it. Yes, I think that's a sensible idea. Shen carers, we haven't covered Shen carers today because well, we've got 60 minutes to cover Zambrano's, which felt like a mammoth task in itself. So we can consider looking into a presentation on Zambrano's if we have time, but the scheme closes very shortly and I'm unsure that will be possible. The grant rate for Chen applications is a lot higher than Zambrano's, hence why we prioritised Zambrano cases. Would the first tier tribunal consider Article 8 in Zambrano appeals and A Timor case prevents it in other cases, but what about specific to Zambrano? Biana, I'm going to put you on the spot for that one. And you're on mute.
Sorry. That's a very interesting question. I think the statutory jurisdiction depends on whether or not there was a human rights claim and whether or not there was a refusal of that claim. I don't think that a special case can be made for, in particular, Zambrano cases. However much we might think that it would make sense to consider everything at the same time, especially in these cases. So I don't think we can carve out, on the basis of the case law as it stands now, a special case, but would be interesting. Thanks.
Thanks, I agree. We've had several questions about slides. Yes, they will be circulated to all registered attendees. Desmond, you have a question about Fratilla. As the Fratilla case concerns EEA nationals and not their family members with pre-settled status, do you think that the outcome of the case would extend to Zambrano carers who would not be EEA nationals?
Well, the glib answer is because the legislation is knocked out, then that would appear to benefit all who are excluded because their settled status is pre-settled status. But I take the point, because they're third country nationals, will there be yet another carve out just against Zambrano carers? And I'll pass that back to Ollie, because that sounds like a pure immigration question. The fact that they are associated with an EU citizen would seem to me to imply that that discrimination is still a problem for the government, but not a benefit problem.
Thanks, Desmond. I think it's too early to hypothesize on that, to be honest. Unless Biana has any, or Nisa have any further thoughts.
Let's get one in the bag before we move on to the complications, perhaps, is the other glib answer.
Yes, I think that is right. Let's wait for Fratilla, see what happens and how long it takes to implement. I mean, Fratilla is obviously about, was brought under EU law. There's probably going to be another challenge about the withdrawal agreement and the scope of the withdrawal agreement and how that applies.
It'll be interesting to see what the Supreme Court has, what's left for them to do if it's been decided in Luxembourg and the same legal team is coming back here subject to quarantine to sit in front of the Supreme Court. Are they going to carry on or wait for the European Court to issue its judgment? It's all very interesting stuff.
Yes, it's a race to judgment. Hearing today in the CJEU and then on to the Supreme Court. I'm not sure if there's a hearing date yet.
Yes, they have, the 18th and the 19th, a very long hearing.
Okay. So we'll, no doubt our social welfare blog will keep people posted about the outcome of those hearings. But yes, I think we wait and see what happens in both those cases. Then we take a view about what, and see what the government reacts, how the government reacts, hypothesizing about them carving out, doing a carve out in relation to Zambranos and the lawfulness of that. I think to an extent would depend on what that legislation would look like. But yeah, all quite hypothetical at the moment, but I can see an argument that it would be discriminatory. Right, back to questions. Biana is currently typing an answer to one of the questions, and I might ask her to say it out loud instead. The Home Office are simply applying blanket refusals to Zambrano applications. I had a client who had a 6-month family permit under Zambrano, applied under the EUSS Zambrano, and it was simply refused by their stating apply under Appendix FM. And I think that's not an uncommon experience. Nisa and Biana, I'll go to Biana first if she's typing.
Well, all I was going to say is that it's an extraordinary situation. I hope your client appealed. In the last quarterly figures of the derivative right refusals, Zambrano refusals constitute 96% of them. it's more than a half, well, around a half of them, a bit more than a half, are refused. And I think your client needs to appeal this. I'm sure that NISA has got more insight.
No, I would agree with that. I haven't come across that situation, but absolutely, they should be appealing.
Yeah. Okay. Can you explain, I think this is for Biana, can you explain again why the issue of exempt person is important?
The reason I was pointing to it is because if you have people who are sharing care, sometimes we still get refusals because one of them is an exempt person. That is, up to 2018, that was in the regulations. Since 2018, it hasn't been in the regulations. Nevertheless, these refusals still happen.
Great, thank you for that. We've got lots of questions, so as with the rest of this seminar, we are going through them at whistle-stop speed. So the next one, how does submitting both an application, an FM application and an EUSS Zambrano application work in practice? Wouldn't one be considered as a variation of the other? Nisa, do you want to have a go at that?
Yeah, so well, the EUSS guidance actually says that if somebody has got a pending application under another part of the immigration rules, and then they apply under the EU settlement scheme, the original application, so for example, the Appendix FM application, will be varied and should no longer be considered unless that application under the immigration rules is an asylum, humanitarian protection, or otherwise based on a human rights claim. So that would include Appendix FM applications, and in that case, it means that they have to consider both applications. Where they have a pending application under the EUSS, and then they make an application under the immigration rules, another part of the immigration rules, then they have to consider both applications. So yes, it could be a variation, but at the same time, they must consider both of them, essentially.
Right, we have another question for you, Nisa, I'm afraid. Being put on the spot, but I'll chip in and Biana can chip in too. My client has a British partner and children in the UK. He is also subject to a deport order outside of the EU regs. He is appeal rights exhausted. Article 8 rejected at appeal. Can he now put in a fresh human rights claim as well as an EUSS application?
Obviously, the fresh human rights claim depends on the facts of the case, whether those criteria would be met. In terms of the EUSS application, I think it would be problematic because the deportation order would mean that they would refuse it.
Refusal.
I mean, then maybe that could give rise to a right of appeal to appeal the deportation order. But I think it would be difficult to say without knowing more, I think, about the circumstances of the case. I don't know what you, Oriana, and Ollie think about this.
Yes, I fear I'm in the same boat. It's not straightforward to answer a question like this without knowing more.
Exactly.
But potentially, yes, you could have all these things going on at the same time.
Great. We only have a couple of minutes left, so I'm going to try and get through as many of these as possible and maybe abbreviate them if necessary. Where two parents live in the UK but not together, would you recommend writing that the applicant is a joint primary carer so that the test of whether the child would remain if they both had to leave the UK will be applied? Where it is not immediately clear if the other parent is a joint carer, do you find the Home Office will make its own assessment of this question regardless of what the applicant writes? That's probably mostly addressed at NISA. But...
So I think they may well be joint primary carers, and they could look into that. I just feel like the Home Office would probably be reluctant to, of its own volition, to recognise that someone is a joint carer unless evidence is provided. So I feel that's a bit of a. I kind of need to know a little bit more about the fact to sort of see what the underlying issue is. I don't know what you think, Boyana.
If it was the DWP, they'd go through their checklist. Who takes them to school? Who takes them to the doctors, etc. And they'd want to have one as primary and the other as the less primary. So,
yeah, my experience has been really uneven, but without making representations, one is not going to get there. And I think one needs to have the case for this clear in their minds. Is there joint care or not? And I think that, you know, if you look at, because the guidance spends a lot of time on this, if you look at the guidance and try to see whether you fit in to their kind of guided criteria, which have a bit of flexibility, then probably the answer will present itself. Either you are a joint carer or you're not, but it's not necessarily rigid. And I think what Nisa said about making representations, I think it's important in every case. So if you're saying care is shared, then you need to say so. You need to pin your colours to the mast, as it were, unless there are massive reasons why you don't want to do that. But yeah.
Yeah, I agree with that. I think we probably have time for one last question. And very sorry for the cases that we are missing, questions that we are missing. We did do quite a good job of keeping to time and have a window for Q&A, but it's clearly a topic that causes quite a considerable amount of questions. So would a Zambrano carer who has been granted pre-settled status under the EUSS when her British child was under the age of 18, apply for settled status if the child turns 18? Well, you need 5 years for settled status application of, so just your child turning 18 wouldn't do that. I don't know if anyone wants to add anything to that answer. No. Well, I think given that we are out of time and we wanted to get back to their afternoon's work, I just want to say thank you very much to Biana, Desmond, and particularly Nisa, who is our guest to Garden Court's webinar today and has been doing much of the heavy lifting on the complicated questions about practicalities of applying with great expertise. So thank you very much, everybody, for attending. Thank you for being so interested and engaged with your questions. Hopefully that has been useful. As said before, our slides will be circulated, and keep an eye on our social welfare blog for news about Fratilla. If there's nothing further, I think we'll say goodbye and thank you for your interest.